At this point in time, I think I'm just going to have to be satisfied being wrong for the right reasons. Viva Frei, Montreal litigator turned YouTuber, and as you can probably note, I do not have my standard office. My wife had to take it to go to work, so I am shooting my videos in the basement today. And as I am sure a lot of you already know, there has been an update in the Parler versus Amazon case. There has been a decision on the TRO, the Temporary Restraining Order Preliminary Injunction, and it was dismissed. Now, I admit I may be somewhat biased in my analysis of this because I did make the prediction that Parler was going to succeed on its request for a temporary restraining order, enjoining Amazon to host its web activities until Parler can find a new alternative. I acknowledge I may be a little biased or tainted, but when I read this decision reads like motivated reasoning. It is not to say that the conclusion is not justifiable. Indeed, if I wanted to come to that conclusion, this is exactly how I would have drafted the judgment, but it just seems to me that the judge had the conclusion in mind before drafting the judgment and drafted the judgment accordingly. For those of you who may not be aware of the entire situation, I would refer you to my previous videos on the subject, but a 30,000-foot overview. Parler is a Twitter-like platform that was hosted on Amazon. The week of the Capitol Hill riots, Apple and Google pulled Parler app from their app store, and Amazon pulled its web services from Parler from the internet. The justification for these actions was that Parler was hosting offensive content on its platform, which violated Google, Apple, and Amazon's rules of service or terms of service, and all three of them wiped Parler from the internet basically overnight. Parler filed suit in which it requested damages on the merits, but it sought the issuance of a TRO, a temporary restraining order, which is basically sort of like an emergency or preliminary injunction. Parler argued, among other things, that they would suffer irreparable harm if the TRO were not to be issued. Amazon argued that they should not be forced to provide web services to Parler, who could not guarantee the respect of the terms of service of Amazon. Parler's lawsuit was based on three separate claims. One was antitrust violations, the other was a breach of contract, and the third was tortious interference with business expectancy. Parler filed suit, Amazon filed a response, Parler filed a response to Amazon's response. I covered all three of them. Now let's get into the judgment. United States District Court for the Western District of Washington at Seattle. Parler LLC plaintiff versus Amazon Web Services Inc. defendant. Order denying motion for preliminary injunction. Introduction. This matter comes before the court on a motion for temporary restraining order, TRO, filed by plaintiff Parler LLC. Parler, docket number 2. Parler is seeking to have the court order defendant, Amazon Web Services Inc., AWS, to reinstate AWS's web hosting services that AWS provided Parler under the parties' customer service agreement. Parler initially filed the motion as one requesting a TRO, but after the court ordered Parler to serve AWS notice, ordered additional briefing, and held a hearing, the parties agree that the motion has been converted to one for a preliminary injunction. Alright, so that's actually an interesting procedural distinction. Parler was initially seeking a TRO, which is a temporary restraining order, and apparently they wanted to proceed ex parte without AWS even being present. The court ordered them to serve on AWS Amazon Web Services, and they basically converted the request from one for a TRO, temporary restraining order, to a preliminary injunction. The judge then goes over the three headers of Parler's claim, which I just did, but then the judge says something which gives you a clear indication of where the judge is going with this judgment right from the intro. It is important to note what this case is not about. Parler is not asserting a violation of any First Amendment rights, which exist only against a government entity and not against a private company like AWS. And indeed, Parler has not disputed that at least some of the abusive and violent posts that gave rise to the issues in this case violate AWS's acceptable use policy. This motion also does not ask the court to make a final ruling on the merits of Parler's claims. As a motion for a preliminary injunction, before any discovery has been conducted, Parler seeks only to have the court determine the likelihood that Parler will ultimately prevail on its claim and to order AWS to restore service to Parler pending a full and fair litigation of the issues raised in the complaint. Having reviewed the briefs filed in support of and opposition to the motion, and having heard oral argument by video conference, the court finds and rules as follows. It is always interesting when the court provides answers to questions nobody asked, but here you have the judge just reminding everybody yet again that First Amendment violations do not apply to Twitter, which is not a government entity but only a private company. People often ask why people don't sue Twitter, YouTube, Google on the basis of First Amendment violations. Well, the clear answer is because they're not government entities, and the other clear answer is that the argument that they are effectively public square, monopolies, utilities, whatever, have not succeeded before the court, and the judge just made this clear yet again. With that said, let's move into the judgment, which basically dismisses all three aspects of Parler's claims. Now, in fairness to me, I did initially predict that the antitrust claim would be very difficult to succeed on. The tortious interference with business expectancy would also be somewhat more difficult to succeed on. The breach of contract was the clearest claim that Parler had, and the judge still dismisses that. But first, let's just go over one or two paragraphs which clearly give you an indication of where the judge is going early on. On January 6, 2021, supporters of President Donald Trump seeking to overturn the results of the presidential election marched on Congress, resulting in a violent and deadly riot at the U.S. Capitol. On January 8, Twitter and Facebook banned President Trump from their platforms. Parler claims that in response to speculation that the president would move to Parler, there was a mass exodus of users from Twitter to Parler and a 355% increase in installations of Parler's app. Parler also claims that the surge during this time was responsible for its failure to deal with a backlog of some 26,000 posts that it acknowledges, quote, potentially encouraged violence, end quote, in violation of the AUP. On January 9, 2021, AWS notified Parler that it intended to, quote, suspend all services, end quote, as of 11:59 p.m. Sunday, January 10. And then the judge cites from an email which was filed as an exhibit, quote, it's clear that Parler does not have an effective process to comply with the AWS terms of service. Given the unfortunate events that transpired this past week in Washington, D.C., there is serious risk that this type of content will further incite violence. Because Parler cannot comply with our terms of service and poses a very real risk to public safety, we plan to suspend Parler's account effective Sunday, January 10th at 11:59 p.m. Now, admittedly, I cheated because when I read this decision, I went straight to the conclusion just to see how it went, but you can see from the phrasing, from the wording of this paragraph, the rhetoric the judge is using, highlighting the risk, highlighting the violence, highlighting the threats that she is going to side with AWS. She has already bought into their argument. And all of the judge's justifications are totally defensible in law. They are justified in law if you want to get there. But I do take issue with the breach of contract argument, but we're going to get there. Let's just start with the antitrust. Actually, before we get into the antitrust, let's just briefly go over the criteria for the issuance of a preliminary injunction. As courts have repeatedly emphasized, an injunction represents, unquote, extraordinary remedy, end quote, that is never awarded as a matter of right. For a preliminary injunction to issue, the moving party has the burden of demonstrating all four of the following elements. 1. That it is likely to succeed on the merits. 2. That it is likely to suffer irreparable harm in the absence of preliminary relief. 3. That the balance of equities tips in its favor. And 4. That an injunction serves the public interest. In the wake of Winter, in which the Supreme Court narrowed the path to an injunction, the Ninth Circuit has maintained that a preliminary injunction, quote, may also be appropriate if a movement raises serious questions going to the merits and the balance of hardships tips sharply towards it, as long as the second and third Winter factors are satisfied. And even though we are at the infancy stages of the proceedings, very little evidence has been adduced, no discoveries have been conducted, the judge comes to the conclusion that Parler has not succeeded in showing that it will likely succeed on the merits. And now, starting with the Sherman Act and the antitrust claim, this is what the judge has to say. At this stage in the proceedings, Parler has failed to demonstrate that it is likely to succeed on the merits of its Sherman Act claim. While Parler has not yet had an opportunity to conduct discovery, the evidence it has submitted in support of the claim is both dwindlingly slight and disputed by AWS. Importantly, Parler has submitted no evidence that AWS and Twitter acted together intentionally, or even at all, in restraint of trade. In short, Parler has preferred only faint and factually inaccurate speculation in support of a Sherman Act violation. AWS, in contrast, has submitted sworn testimony disputing Parler's allegations. Setting aside the fact that, in my humble opinion, the Sherman Act antitrust claim was the weakest of Parler's arguments, this reeks of motivated reasoning. Basically, the judge is saying, Parler said something, Amazon denied it, I believe Amazon, therefore I don't think Parler has a likelihood of success. But it gets even worse as far as I am concerned when it comes to the breach of contract claim. The gravamen of Parler's breach of contract claim is that AWS terminated the agreement without providing Parler 30 days to cure any alleged material breach. Parler claims it is entitled to the 30-day cure period based on a provision of the CSA that provides, quote, either party may terminate this agreement for cause if the other party is in material breach of this agreement and the material breach remains uncured for a period of 30 days from receipt of a notice by the other party. As noted above, Parler alleges that AWS notified Parler that the latter was in material breach for the first time only hours before suspending or terminating services. AWS responds that it is Parler, not AWS, that has breached the agreement. In particular, AWS claims that Parler breached Section 4.2 of the CSA, which requires Parler to, quote, ensure that Parler's content and Parler's end users' use of Parler's content will not violate any of the policies, end quote, including AWS's acceptable use policy. And given that the judge previously agreed with Amazon's reasoning, why would it be any different when it comes to this claim?
It isn't.
Parler has not denied that content posted on its platform violated the terms of the CSA and the AUP. It claims only that AWS failed to provide notice to Parler that Parler was in breach and to give Parler 30 days to cure, as Parler claims is required per section 7.2b(i). However, Parler fails to acknowledge, let alone dispute, that Section 7.2b, two little i's, the provision immediately following, authorizes AWS to terminate the agreement, quote, immediately upon notice, end quote, and without providing any opportunity to cure, quote, if AWS has the right to suspend under Section 6. And Section 6 provides, in turn, that AWS may, quote, suspend Parler's or its end user's right to access or use any portion or all of the service offerings immediately upon notice, end quote, for a number of reasons, including if AWS determines that Parler is, quote, in breach of this agreement, end quote. In short, the CSA gives AWS the right either to suspend or to terminate immediately upon notice in the event Parler is in breach. So Amazon can immediately terminate or suspend if Amazon determines that Parler is in breach of the agreement. Then what purpose does the notice to cure provision serve? This interpretation effectively denies any meaning whatsoever to the notice to cure period, so you are left with a right without a recourse, which is basically no right whatsoever if Amazon can terminate at any time whatsoever. So I totally disagree with the judge's interpretation of the agreement, but at the end of the day,
the judge's opinion is the only one that matters.
Unless it goes to appeal and then to the Supreme Court, in which case those judges' opinions are the only ones that matter. But any interpretation of a contract which denies meaning to one of the provisions, one of the most key provisions, is, in my mind, a flawed interpretation. And so moving from this flawed interpretation, the judge also comes to the conclusion that on the breach of contract claim, Parler has not succeeded in showing that it will likely succeed on the merits. Parler has not denied that at the time AWS invoked its termination or suspension rights under sections 4, 6, and 7, Parler was in violation of the agreement and the AUP. It has therefore failed at this stage in the proceedings to demonstrate a likelihood of success on its breach of contract claim. Another reason why I strongly disagree with the judge's interpretation that basically gives no meaning to the notice to cure period is that now she has effectively greenlighted Amazon to shut down anyone at any time whatsoever if they find so much as one element on their website or web platform that violates Amazon's terms of service. And anybody who has spent even an hour online knows that there is such volume of content being posted and uploaded at any given point in time that it's virtually impossible to prevent it from being uploaded in the first place. The only thing you can do is respond in due course. But given the judge's interpretation of the contract, all Amazon has to do is find one element of something that violates the terms of service or the AUP in order to basically not have to follow the notice to cure period, and they can shut down anyone overnight for whatever reason. No breach of contract because according to the judge under the contract, Amazon can suspend or terminate if Amazon determines that the other party is in violation of the agreement. Amazon may have won on this decision, but this decision is going to have some pretty serious business consequences for Amazon now that each and every one of their clients appreciates that they live at the mercy of Amazon's discretion. Now let's get into why the judge dismissed the third aspect of Parler's claim, the tortious interference with business expectancy. Parler has failed to allege basic facts that would support several elements of this claim. Most fatally, as discussed above, it has failed to raise more than the scantest speculation that AWS's actions were taken for an improper purpose or by improper means. Conversely, AWS has denied it acted improperly, justifying its actions as a lawful exercise of rights it had pursuant to either the suspension or the termination provisions of the CSA. Further, for the reasons outlined supra, Parler has failed to demonstrate the likelihood that AWS breached the CSA. To the contrary, the evidence at this point suggests that AWS's termination of the CSA was in response to Parler's material breach. Parler has therefore not demonstrated a likelihood of success on this claim. Having concluded that Parler has failed to show the likelihood of success on the merits of the claim, that makes the judge's job easier with respect to the remaining elements, so let's just get into those quickly. Irreparable injury. Because likelihood of success is a threshold inquiry. When, quote, a plaintiff has failed to show the likelihood of success on the merits, the court need not consider the remaining three winter elements, end quote. Given the gravity of the issues presented, the court nevertheless will do so. The injuries Parler alleges in its complaint and its motion may be irreparable. That is a fair argument. Damages that can be compensated monetarily typically do not serve as the basis for the issuance of preliminary injunctions, although there is the argument that loss of clientele, loss of goodwill, loss of a business entirely is irreparable harm that can serve as a justification for the issuance of a preliminary injunction. But it's the judge's call. The judge has made her call. She is siding with Amazon on everything here, even the balance of hardships, and that is where I have a real problem with this judgment. Second, while the, quote, balance of hardships, end quote, may fall heaviest on Parler in the form of potential monetary loss, AWS has convincingly argued that forcing it to host Parler's users' violent content would interfere with AWS's ability to prevent its services from being used to promote and, as the events of January 6, 2021 have demonstrated, even cause violence. It cannot be said, therefore, that the balance of hardships tips sharply in Parler's favor. Now, I think I hear a lot of you screaming at your computers right now that, first of all, of everyone who did something bad at Capitol Hill, apparently none of them even had a Parler account, and if this is the new standard, shut down Twitter, shut down Facebook, and shut down YouTube immediately. Well, maybe not YouTube so much, but a lot of coordination was in fact conducted on Twitter and Facebook. So if this is the standard, shut down Twitter and shut down Facebook. Or at the very least, do not use it as the justification to shut down Parler. But according to the judge, Amazon has argued convincingly. The judge is thoroughly convinced even when it comes to the balance of the equities, so let's just end on that. The court explicitly rejects any suggestion that the balance of equities or the public interest favors obligating AWS to host the kind of abusive, violent content at issue in this case, particularly in light of the recent riots at the US Capitol. That event was a tragic reminder that inflammatory rhetoric can, more swiftly and easily than many of us would have hoped, turn a lawful protest into a violent insurrection. The court rejects any suggestion that the public interest favors requiring AWS to host the incendiary speech that the record shows some of Parler's users have engaged in. At this stage, on the showing made thus far, neither the public interest nor the balance of equities favors granting an injunction in this case. Now, for anyone who has been following my vlogs for any period of time, you know that I am a fervent defender of freedom of speech. I do, however, draw the line at targeted harassments, calls for violence, threats, doxing, etc., which I know some of you are going to say makes me something of a hypocrite or have a double standard on freedom of speech, but I do draw the line there as well. With that said, I do understand the nature of the internet, the sheer volume of comments, posts going up there, and if this standard is the new standard, then the internet is safe for no one. Setting aside the fact that apparently no coordination was actually conducted on Parler, none of the people arrested even had Parler accounts, at the very least as of the date of the filing of those proceedings, and it seems by all accounts that a lot of material coordination occurred on Twitter and Facebook. Following the judge's reasoning, all it's ever going to take to shut down anybody on the internet is, I don't know, say a brigade of people going to post that type of rhetoric on that website in order to justify shutting it down. And again, recall, the argument was not that Parler was refusing to take this type of content down. They did in fact take it down, and they did in fact take it down relatively quickly. The issue was that they couldn't do it instantaneously given the backlog and influx of this type of content that was coming in as a result of the influx of people coming in. So it was not a question of Parler refusing to comply with the terms of service. It was just that Amazon said they didn't do it quickly enough, so we shut them down overnight. And Amazon just got the blessing from this judge, which should serve as a stark reminder and warning for everyone out there. Now let's finish up this judgment where it ends with the conclusion. Conclusion: Parler has failed to meet the standards set by the Ninth Circuit and US Supreme Court precedent for issuance of a preliminary injunction. To be clear, the court is not dismissing Parler's substantive underlying claims at this time.
At this time.
Parler has fallen far short, however, of demonstrating as it must that it has raised serious questions going to the merits of its claim, or that the balance of hardships tips sharply in its favor. It has also failed to demonstrate that it is likely to prevail on the merits of any of its three claims, that the balance of equities tips in its favor, let alone strongly so, or that the public interests lie in granting the injunction. This is only the decision on the preliminary injunction. There will certainly be a continued lawsuit in this case, although it is already not going Parler's way, but stay tuned for updates. I will provide update vlogs as things develop. With that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section because it feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. We've got PayPal, Patreon, subscribe to our YouTube membership. We've got merch, Politics Ruins Everything, although I think I'm going to create a shirt now that says wrong for the right reasons. If you want to follow Robert Barnes and I and support us on Locals, we have a page on Locals. It is called vivabarneslaw.locals.com. All of my content is also on rumble.com, where you can find me under Viva Frei. But more important than any of that, take care of yourselves, check out on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out.